Prosecutor in the Delphi murders case believes they have a very solid case against Richard Allen. Nicholas McClelland, in a statement reiterating his request to keep the probable cause sealed, writing, "We strongly believe the evidence shows Richard Allen was involved in the murder of Libby and Abby, regardless of the ruling. We believe we have a very solid case against Mr. Allen and look forward to making our argument at trial." It does not say directly he believes Allen killed the girls back in 2017. The prosecutor issued the statement one day after requesting a gag order in the case. The judge expected to make a ruling on both requests in the next week or two. And let's welcome in Brian Buckmeyer, criminal defense attorney and one of the hosts of Law and Crime Daily weeknights at 11:30 here on Wish TV. And Brian, good to have you on. Happy Thanksgiving, sir. I know you've been following the Delphi murders case and the fact that the probable cause affidavit is sealed. Just how rare, in your opinion, is for that paperwork to remain sealed even after the suspect has been arrested?
Well, thank you for having me, and happy Thanksgiving to you and everyone watching. It's rare for two reasons. One, the type of cases where you typically see this. It's not the average case that goes about. It's usually for homicides, and homicides that are intricate enough that more investigation needs to happen even after a person is arrested. So you could cut it down to that small portion of types of cases. Then you start to ask a question of, why do we need a protective order or a sealing like this? It's oftentimes, again, when it's not just, hey, smoking gun, person dead. It's a mystery that needs to be solved, and that information cannot be made to the public until it is solved.
So the fact that Richard Allen is already in custody, but prosecutors want to keep the documents sealed, does that likely mean there are more suspects and more arrests possible in this case?
So they've already hinted at Allen's arraignments that there are potential for other suspects, but more importantly, it's about interrogations for both potential witnesses and suspects. Think of it this way. If they go and arrest someone because maybe Allen is the murderer, or maybe he's just the person who staged the scene to make it look like something that it wasn't, in questioning that suspect or questioning that witness, they don't want that person to be able to pull from information that they heard publicly. They want to make sure that if they know about this case, they know about this case because they're involved in one way, shape, or form.
So one of the options before the judge is to release a redacted probable cause. How much leeway does a judge have in redacting information? And how much could she block from public view? And what types of information are we talking about?
The judge has all the leeway in the world. They can just show you one word, they can show you none, they can show you everything. What I think is likely going to happen is the judge is probably going to have what's called an attorney eyes only type of release, where the attorneys get to see it. Maybe they allow the attorneys to share with their client, Mr. Allen. Maybe there's a gag order then that they cannot speak to the public. And then in terms of what the public gets is what the police or prosecutor asks for the judge to give to them, in order to allow for that investigation to continue without any interruption. This allows for Allen and his defense attorneys to have all the information to defend him, but still protects the integrity of the investigation. It's kind of a mixed bag as to what the judge cannot do. Speaking of the attorneys, his attorneys call the evidence in the PC flimsy. At what point do they get to see all of the evidence in the case beyond what's in the PC? So hopefully pretty soon, because the way the Indiana law works is they actually get to depose or question potential witnesses. So all of that information needs to be given to the defense attorney as soon as possible so they can pretty much do their own investigation of the case as well. Try to see if there's a defense here, try to see if maybe this is the wrong person they got caught up in this case, or maybe the evidence is so strong they're looking to take a plea. And so the judge will kind of create a timeline as to when just casual discovery be turned over, but then also when motions can be argued for the defense to say, we're entitled to this, now give it to us. All right, well, Brian, I have one more question for you before I let you go, and I thank you for taking some time. All of this pretrial discussion, just how difficult does it make it for a possible fair trial for Richard Allen? It makes it very difficult because the jury is going to be the people that selected from that community, and they're going to be bombarded with information about this case. It could go either way. It could go to his advantage. Maybe we end up finding that there's another suspect whose DNA was under one of their fingernails, and then he's less guilty. Maybe we find out information that is not corroborated or cannot come into the trial, but everyone hears about it as it applies to Mr. Allen. And And so that can make it very difficult for finding a jury at its start point, and then even more difficult if a jury is found to find a fair trial.
All right, well, we'll see what happens. Brian, we appreciate your expertise, and thank you so much for coming on with us. Have a happy Thanksgiving, and we'll look forward to maybe talking with you in the future, sir.
My pleasure. Happy Thanksgiving to you all.